all this pushing of conspiracy theories doesn't help anybody, and it's really not helping Charlie Kirk's family and anything that Charlie Kirk stood for. If he was alive today, he would want you to find the truth in evidence, not the truth in conspiracy theories that make you money on the internet.
DNA consistent with Robinson's was found on the trigger, other parts of the rifle, the fired cartridge casing, 2 of the 3 unfired cartridges, and the towel. We have not received the discovery, and I'm not talking about expert notice, I will address that. We have not received the physical evidence and the electronic evidence that supports those assertions made by Mr. Gray when he swore to the probable cause statement attached to the information.
Let me talk about something that really matters to me. In 1991, the National Law Enforcement Officers Memorial was built to honor the men and women who gave their lives in the line of duty. Since then, over 24,000 officers have been added. Let that sink in. And every year, more names are added. This year alone, 363 officers will be honored, including 109 who died just last year. This is a living memorial because the sacrifice doesn't stop. Every name on this wall represents somebody who left home and never made it back. A mother, a father, a son, a daughter. And for the families left behind, this memorial means everything. It's a promise that their loved ones will never be forgotten. It costs $1,000 to engrave a name on that wall, ensuring it will forever be a part of our nation's history. And a full tribute, which includes a plaque and having their name read aloud at the annual candlelight vigil, costs $5,000. That vigil takes place every year during National Police Week in Washington, D.C. And I'm telling you, it's one of the most powerful things that you'll ever see. And here's the truth. This memorial doesn't receive federal funding. It relies on people like you. So if you support law enforcement, this is a real way to show it. Help us honor the fallen and make sure that their sacrifice is never forgotten. The Tyler Robinson's case. I've been telling you guys this for 100 years, and I hope that you now listen to me. All of these loony naysayers who claim all these crazy things without evidence, you cannot listen to them. There's a dummy that made a video about me, and I really respect his service. He was a Green Beret, but the guy's a lunatic, anti-Jewish, hating fool, and therefore everything he do has to go off a cliff. Going out and saying, don't listen to Brandon Tatum about this. Listen to fake conspiracy theories. Now, here is evidence from the court hearing, and I'm going to explain it to you. I told you guys from the beginning that Tyler Robinson killed Charlie Kirk. Now, whether somebody was behind it, I don't know. I don't have that information. And if you do have that information, let us know. But all this pushing of conspiracy theories doesn't help anybody, and it's really not helping Charlie Kirk's family and anything that Charlie Kirk stood for. If he was alive today, he would want you to find the truth in evidence, not the truth in conspiracy theories that make you money on the internet. So here's the court hearing. I'm going to clarify this because a lot of people are going out and saying that, oh, the prosecution refused to give information to the defense. That's not true. The prosecution refused to give information to the defense because they're afraid of the preliminary hearing and that they don't have evidence. That's not true. A preliminary hearing is not for it's discovery and for you to do all this other stuff. It's just to establish probable cause. I don't mean to get upset, but these lunatics who have never in their lives done an investigation tries to tell people like myself and others how this stuff works. But here's the judge, and here is the prosecution and defense for you to see for yourself. Roll the clip.
So one of the questions that's before the court, and Mr. Novak, it goes to the heart of the matter for this court as the court is weighing whether the continuance should be granted or not. Has defense reviewed all the discovery that has been presented up until this point?
Time out. I want to make sure you guys are clear on this. This is for continuance, right? They have the preliminary hearing that's supposed to be established, probable cause. The prosecution is ready to go. The defense is trying to push it beyond what's reasonable. They want a continuance. They want this to be dragged out for 6 months. And this is the judge articulating to the defense, what is your merit for continuance? Roll the clip.
For a preliminary hearing set for next month.
We have reviewed the discovery that is tied to the exhibits that the state intends to offer at the prelim where there is discovery available.
That's it. That's all you need.
If the court is saying, have you reviewed the thousands, have the lawyers reviewed the thousands and thousands and thousands of pages of discovery that are well documented in the index that Mr. McBride provided the court privately? The answer is no. Our paralegals are doing their best to organize it, but have counsel reviewed that discovery, and have we had reasonable time to do so? No, because it's gigantic and it's voluminous. We know that some of it has nothing, some of it has been provided in what I guess the state would call an abundance of caution. 30 days worth of surveillance video from UVU. We don't believe that we even need to review 29 of the 30 days. So we're not going to waste time and resources reviewing hundreds of surveillance camera hours without some suggestion that we need to, and we don't believe that we do. Have we reviewed, every FBI report interviewing people who claim to have known Mr. Robinson or known his roommate? Yeah, we've reviewed all of that. Have we reviewed the forensic materials that we have received? Yes. Have we reviewed all the law enforcement reports about the events at UVU? I mean, I can only speak for myself. No.
All right.
Because it's so.
Let me put this in perspective for you. And you guys can watch this on your own if you think that I don't give it justice. But putting this in perspective, the judge is asking him, have you had a chance to review the documentation that was provided by the prosecution for the preliminary hearing, not discovery or anything else, for the preliminary hearing of probable cause or to establish probable cause in this case? He pretty much said yes. The judge is not asking you, did you review 100,000 documents that are irrelevant to the probable cause statement, the probable cause verification? This guy's grandstanding and going off on this tangent. And here is, let's skip this one and go to the next clip with the prosecution to tighten this up a little bit. Now, this is what the prosecution is now saying, which to me seems reasonable, and why the defense is not acting in good faith, in my opinion. They want to continue to push this thing further and further and further along, trying to find an angle. There ain't no angle. There's a myriad of amounts or copious amounts of evidence that Tyler Robinson did this. Even the defense just articulated that, have we reviewed 30 days of UVU footage? They've given them plenty of information. Roll the clip.
We've narrowed it down, given greater notice than is required by the expert notice statute, in fact. More than a month's notice of all the exhibits and witnesses we're going to call. There's 6 witnesses we're going to call. There's about 35 exhibits we're going to provide. Most of those exhibits were provided to them clear back in 2025. The last one I think was provided maybe, I've got it on a list here, but I know you have it in that letter I sent, Mr. Novak, but the last one was provided there's a tool marks report that was provided March 12th, okay? So under these circumstances, no, they can review these 35 exhibits. We've got plenty of time to review them. I'm sure between all of them, they've reviewed all these exhibits.
All right. I thought we had one more from the prosecution. Okay, roll this one because this gives more clarity on why this is unreasonable for them to continue to prolong. And this debunks what people are saying when it comes to the prosecution being unwilling to disclose information to the defense because they're somehow afraid. Roll it.
So the question is a continuance necessary for the purpose of a preliminary hearing? And to understand that, you have to understand 2 things. 1, what is the purpose of the preliminary hearing? And 2, what is the evidence that's likely to be presented at the preliminary hearing? And then you get to 3, is a continuance necessary? First, the purpose of a preliminary hearing is clear. There's very few principles in Utah law that are more clear than this. There is one purpose to the preliminary hearing and one purpose only, and that is to determine probable cause. Every time a defendant or a trial court tries to expand the preliminary hearing beyond that, whether it's on constitutional due process grounds or discovery grounds or something else, the courts uniformly and repeatedly reject those arguments. There's only one purpose. It's clear in the Constitution. It is to determine probable cause. It's not a discovery hearing. It's not a due process notice hearing where the defense learns what the state's theories are or what evidence the state is going to present at the trial. It is not a suppression hearing under the Fourth Amendment. It's not an admissibility hearing under the rules of evidence, and it's certainly not a 702 hearing. It is only one thing, a probable cause hearing, and that's it. That's important because that relates to what a continuance being necessary means, right? Can the defense show they need to continue this hearing because it's necessary to a determination of probable cause? If they can't, it's unnecessary and it's going to infringe on the victim's right to a speedy trial, as well as the state's ability to present the case. Justice delayed is justice denied, as the saying goes, and that's because it affects a victim's right to a speedy trial. It affects the public's perception of legitimacy of the prosecution and the judicial system, and it has real effects on the evidence that may be presented at trial.
And let me give you my theory on what they're trying to do here. And it's just my opinion. It appears, based on articulation from the prosecution, and we've seen all the evidence, and we already know that they have video evidence of Tyler Robinson going onto campus, into the stairwell, getting up in a shooter stance on his sniper setup, taking the shot. They have video evidence of all this, taking a shot, running and jumping off the building and running into the community. Then they have surveillance of people's home cameras where they see him running away from the spot where he dumped the gun at. They got so much overwhelming, compelling evidence that it's not even close. And they're articulating very clearly, they're giving them enough to go forward in a preliminary hearing. The defense wants to prolong this because they're trying to, the longer you span this out, the more people are going to distrust the prosecution, the more people are going to have, more conspiracy theories that are put out there, the more that the jury can be tainted, the more that they can create arguments along the way to try to get this guy in a position where he won't get the death penalty. That's all that they're doing. None of them are contesting the validity of all this evidence that's being presented. You don't get 30 days and 20,000 electronic communications because there's no evidence. That means there's a plethora of evidence. This is going to be an open and shut case. It really is. But the defense wants to create an environment where something can go wrong between there and then so that they can have some potential to get him off the death penalty. And there's one more thing that I want to touch on because people are talking about the 30-06. The idiot that I was telling you about early on, shout out to his service as a Green Beret, but he's a complete idiot. The guy is saying that now that they've determined that the bullet is a 30 caliber, that all of a sudden Brandon Tatum is dumb because he don't know what caliber mean and what it represents. I get so sick of these people because just because you served in the military don't mean you're the only person that know about guns. Fool, I was on the SWAT team. All the guys that trained us on the SWAT team, all of our SWAT leaders were all in the military. Many of them were Navy, not Navy SEALs, but they were Marines in tactical environments in the military, deployed to combat zones, and we trained with Delta. We had annual training with Delta. And we used all of their training tactics when we do our training. So it was just like paramilitary. And our rules of engagement were quite different. So anyway, just so you guys know, they discovered that the bullet was a 30 class of a round. The gun that's used shoots 30 class weapon rounds, which is 30-06. Those two things are reasonable to draw the conclusion together that bullet came from that gun. When you have that person on camera using that gun to shoot Charlie and then ditching the gun with his DNA on it and his family identifying the gun belongs to the family and also it being identified as the person on the camera, also made admissions that he was the one that took Charlie Kirk out and shot Charlie Kirk and killed him. All of that together, And then you have the gun, the bullet that's fragmented enough that it cannot be test fired against the gun, so it can't be proven that it came from the gun or didn't come from the gun. It's inconclusive. When you designate that it's a 30 class round, it's reasonable to believe that it came from a 30 class gun. That rules out a 5.56. That rules out, a 9mm. That rules out a whole bunch of other different caliber weapons. So that is reasonable, beyond a reasonable doubt that bullet came from that gun. That's what it comes down to. That fool said that there's no case if they don't have that. That's a lie. The preponderance, not preponderance of evidence, but the voluminous nature of all that evidence together proves beyond a reasonable doubt that kid did it. All right, let's get to the next topic.